Good afternoon, everyone. My name is Brad Sears. I'm the Associate Dean of Public Interest Law here at UCLA School of Law and also founding director of the Williams Institute. We're so glad that you can join with us today in really what is an incredible panel discussing some very difficult cases by the Supreme Court that have just come down really in the last 24 hours or so. So I'm incredibly honored to be with the folks here today who've worked quickly to provide you analysis about these cases. There will be other panels, future panels discussing these cases, I'm sure, over the next weeks and months here at UCLA Law. Today's discussion is sponsored by the Williams Institute on Sexual Orientation and Gender Identity Law and Public Policy, the Center for Reproductive Health, Law and Policy at UCLA, UCLA's really the premier critical race studies program in the country, and the school's public interest programs. Before we jump into the panel, I'm also thrilled to be able to introduce our just incredible interim dean at the law school, Russell Korobkin.
Thanks, Brad, and thank you all for joining us today. This is the kind of panel where it makes me incredibly proud of our remarkable programs and institutes that are able to pull together the expertise of our tremendous faculty. And we have wonderful speakers today that are going to discuss, as Brad said, 3 decisions of the Supreme Court that just came down in the last 27 hours or so, and are, I think, arguably the 3 most momentous decisions of the term nationwide, and also have a lot of personal importance to many members of our community here at UCLA. And we're just delighted to have our faculty experts that are going to be able to discuss, dissect, analyze the implications of these rulings. So I don't want to take any more time. I want to turn it over to our experts. So I'm going to enjoy the conversation.
Great. Thank you, Russell. Today's discussion, we have 4 speakers who are going to discuss the cases as well as their implications for UCLA and the School of Law. And then we'll have some time at the end for questions and answers. If you have a question, please enter it in the Q&A function on your Zoom. You should be able to see that little Q&A button at the bottom of the screen, and you can enter it there. I'm only going to briefly introduce each panelist right before they begin to speak, but I'll say this about all 4 of them collectively. They're incredibly brilliant. They are each engaged in law and policy and really informing public discussion about law and policy. And they all care deeply about their students and this ongoing project that is UCLA and UCLA School of Law, really a public service project, not only for all of us here in California, but more broadly in public education. We're going to start today's discussion with the affirmative action cases that were decided yesterday with distinguished professor of law, Cary Kang, who also was UCLA's founding vice chancellor for equity, diversity, and inclusion. Thank you, Jerry.
So it's great to be here, Brad. I have law professors, as you know, can be verbose. I have 10 minutes, and I want to say 3 things about the recent case SFFA versus Harvard and UNC. 1, what the Supreme Court did. 2, Asian Americans. And 3, a new compelling interest. Maybe it's an old one. So let me start with number 1, what the Supreme Court did. The Supreme Court effectively overruled 45 years of precedent stating that diversity was no longer a compelling interest. I think most people who are legally trained understand that when a state government, when the federal or state government exercises its power explicitly and uses race, that it is subject to strict scrutiny. Strict scrutiny, as you recall, requires a showing of a compelling interest, and that the means used are narrowly tailored to furthering that interest. So you have to figure out what counts as a compelling interest. There aren't that many. The most important one was remedying past discrimination committed by the actor itself recently. The other one was, for purposes of colleges and universities, educational benefits of diversity. And for 45 years, we've kind of had a truce. Since Bakke was decided back in 1978, we've had essentially a political and a jurisprudential truce that said promoting educational diversity through demographic and racial diversity was a compelling interest, that it was good pedagogy. The court effectively overruled that in the cases that were handed down yesterday, principally by suggesting that these so-called educational benefits are so vague and amorphous, such that they couldn't possibly be measured or considered seriously, quantified, and so the court would no longer consider them to be a compelling interest. In effect, as Justice Sotomayor in dissent wrote, the Supreme Court essentially insisted upon a special, careful, specific measurability requirement that really didn't exist before. Because if you remember constitutional law, there are just a lot of different compelling interests that don't seem that easy to measure. And in Justice Sotomayor's own dissent, she pointed out a couple of examples. For example, like maintaining solemnity and decorum in the execution chamber has been deemed to be a compelling interest, just in the case decided by Chief Justice Roberts just in 2022 in Ramirez versus Collier. Or protecting the integrity of the Medal of Honor is a compelling interest. United States versus Alvarez decided in 2012. And in work that I do, all the things about indecency, protecting the physical and psychological well-being of minors is also a compelling interest, as decided by Sable Communications back in 1989. So, as you know, there are lots of things that we call compelling. We usually don't have instruments to measure what counts as compelling to 3 significant digits. And it looks like the court is nevertheless saying these things about educational diversity and the pedagogical benefits of that kind of diversity is so vague, so uncertain that we can't call it compelling. Whether that's consistently applied, those requirements, obviously is something that people will have different views on. The likely impact of this is that we will have Proposition 209-like consequences across the country. It doesn't apply only to state actors per the Equal Protection Clause, but because Title VI, a federal statute, which applies to any organization that receives federal dollars, has been read largely coterminous with the Equal Protection Clause. Because of Title VI, private universities like Stanford, USC, and Harvard will also have to abide by this holding. We should all expect a substantial drop in the next admission cycle of underrepresented minorities, and generally speaking, a down and out move for such students in admissions. I think overall, bad consequences. That's number one, what the Supreme Court did. Let me talk briefly about number 2, about Asian Americans, because it's work that I've done for a long time. SFFA is not a grassroots organization. It is in some ways an AstroTurf organization created by Ed Bloom. He's on the record saying that he needed sympathetic plaintiffs. I needed Asian plaintiffs, so I started, one of his various organizations. That is actually in the First Circuit opinion, quoting his testimony. And it's politically effective. Leading with Asian Americans as the victim of affirmative action tells a powerful story. I'm going to be honest with you. You and I, we might disagree about the pluses and minuses of race-conscious affirmative action. I'm not saying there aren't hard policy questions associated with this stuff. Of course there are, and most polls reflect that. But you and I, we should all agree that discrimination against Asian Americans is a bad thing. There should not be an open conversation about that. What I mean by discrimination against Asian Americans is treating Asian Americans worse than white students, what I've called in the literature negative action against Asian Americans. Now, that kind of discrimination is hard to detect, but if you use sort of careful statistics and social science, you might find that the reason why Asian Americans might be treated worse than white folks is principally because of the preferences given to legacies, athletes, in a really good paper that our colleague Sharad Thaxton has just published, and implicit biases infecting personal ratings and recommendations. So if Asians, right, are being treated worse than similarly situated whites, it's probably because of those things: legacy preferences, athletic preferences, and implicit bias. If you really cared about discrimination against Asian Americans, how would you fix the problem? Well, you would end legacy preferences, you would end athlete preferences, and you would make sure that you would put guardrails and checklists that sort of cabin in how we use personal recommendations and personal ratings. But what's interesting is that ending race-conscious affirmative action does nothing to counter these causes for discrimination against Asian Americans. And the fact that SFFA never asked to get rid of legacy preferences, never asked to get rid of athlete preferences, never asked to actually change the way personal ratings are done to cabin implicit bias, I think reveals their true underlying motivation. There are hard arguments we can go back and forth on whether or not there are some zero-sum games, such that the Asians might be hurt in some sense if they're not included in affirmative action programs. I get that. If you treat Asian Americans indistinguishably from whites, what I call neutral action, indistinguishably from certain ethnic groups or subgroups of whites, like Jewish people, I get it. Everyone who's not in an affirmative action program could, complain. Oh, other people are included, and so they get benefits, we don't. I understand that conversation. And I am willing to concede that we could have good faith disagreements about the policy arguments in favor or against affirmative action. All that I'm asking folks out in the audience, especially like my Asian brothers and sisters, is do not let your outrage against Asian American discrimination be hijacked and deployed against race-conscious affirmative action. They're separate questions. We can be unanimously against Asian American discrimination that treats Asians worse than whites and still have a nuanced conversation about why race might still be a relevant factor to consider in admissions in affirmative action. That's number two. I got like 2 minutes left, and I'm going to do number three. A new compelling interest, or maybe it's an old one. If diversity is no longer a compelling interest, what do you got? What do you got? I mean, stopping race riots in prison, but universities aren't doing that. The only other one, it was remedying prior acts of discrimination caused by the institution itself, but no college or university is actually admitting that they recently discriminated against Black and brown folks. So what do you have? I want to point out that there remains one important compelling interest. There has always been a compelling interest to stopping race discrimination right now. Indeed, in 303 Creative, which again, we will talk about later on today, the court specifically states that the court has recognized that governments in this country have a compelling interest in eliminating discrimination in places of public accommodation. So getting rid of discrimination right now, stopping it, is always a compelling interest. That explains all of our anti-discrimination laws. Indeed, Devin Carbado, again, a professor here, one of our esteemed colleagues, wrote an important article calling out footnote 43 in the original Bakke 1978 opinion, where Justice Powell writes the following: racial classifications in admissions conceivably could serve a fifth purpose, one which petitioner does not articulate: fair appraisal of each individual's academic promise in the light of some cultural bias in grading or testing procedures. To the extent that race and ethnic background are considered only to the extent of curing established inaccuracies in predicting academic performance, it might be argued that there is no preference at all. So I'm trying to say that stopping discrimination right now is a compelling interest. The best social science, and I do a lot of work in social cognition, that comes from implicit bias and stereotype threat, reveals how we might not actually be fair and square in how we measure people and how we give a fair shot for incoming students to actually succeed to their true capacities. Sometimes, in order to counter implicit bias and to counter stereotype threat, you can use race-neutral means to design the right systems and environment. But sometimes you need to use race-conscious means to build up a critical mass, to be mindful of affinity groups, to again make sure that we don't actually use mental shortcuts to judge and evaluate people consistent with the implicit stereotypes we might have. If you can make that case, think about it. Compelling interest equals stopping discrimination. And to the extent that there's anxiety that all this stuff is vague, amorphous, can't be measured, one of the things that social science can do is measure things pretty carefully. And it's going to be measured more specifically to more significant digits than the compelling interest of the honor of, the Medal of Honor or other kinds of nebulous topics and objectives that we consider a compelling interest in other parts of constitutional law. I've gone a minute over. Thank you for your time.
Thank you, Jerry. That was excellent, and I think really leads us right to the next discussion, which is going to be led by Professor of Law and McDonald, Wright, Faculty Chair of the Williams Institute, as well as the Faculty Chair for the Center of Reproductive Health, Law, and Policy. We're so fortunate to have Cary Franklin with us here today to discuss the 303 creative decision that was decided this morning. Thank you, Cary.
Thanks, Brad, and hi, everybody. I want to start by saying I finished reading this decision half an hour ago. This is not the context in which I would normally like to opine on a complicated Supreme Court opinion, but I'm going to do my best here. So this case was 303 Creative v. Alanis. The case involved a Colorado website designer or a graphic designer who just said she wanted to expand into the area of wedding websites. That hadn't been part of her business, but now she wants to start offering wedding websites. But she is a conservative Christian and she doesn't believe in same-sex marriage. She believes those marriages are false and that they are not true marriages. And she believes that she can't create websites for same-sex couples. So she just wants to get into the website business, but only create wedding websites for different sex couples. The problem she runs into is that Colorado has a public accommodations law that bars discrimination in public accommodations on a number of grounds: race, sex, disability, religion, sexual orientation. And so if you hang out a shingle and you offer your goods and services to the public at large, you're a public accommodation. Colorado law says you can't discriminate against same-sex couples. So she argues that her First Amendment free speech rights are violated by this law, right? She's not going to be able to get into this business and express herself because Colorado is barring her from speaking her message. I just want to point out at the beginning, this is not a religion claim. This is not a free exercise religion claim where she's saying, as a Christian, I should get an exception from the law. She is saying something different. She's saying this anti-discrimination public accommodation law violates my right to speak the message I want to speak and compels me to speak a message I don't want to speak, which is that same-sex marriage is okay. So she lost in the courts below, the district court and the 10th Circuit. And those courts and Colorado itself argued that that the law says if you open your doors to the public and make your goods and services available, you have to take all comers. So if you're going to make wedding websites, you have to make a wedding website for anyone who walks into your door and wants such a website. That's not a violation of free speech, that the purpose of that law is not to target any particular kind of speech, but to guarantee equal access to all Coloradans and equal dignity to all Coloradans. There has been a long history of people being excluded from public accommodations on the grounds of race and sex and sexual orientation. Side note here, our moderator, Brad Sears, and Christy Mallory at the Williams Institute have written an article that traces the history of that discrimination in public accommodations against LGBT people, which Justice Sotomayor cited today in her dissent. So kudos to you two. So Colorado is saying we have this long history. We passed the law to stop that history. And so businesses have to make their services available. We're not going to call that a free speech violation. They can still speak. She can still say she doesn't like same-sex couples. She doesn't like interracial couples. She doesn't like women. She doesn't like Black people. Whoever she doesn't like, she can still say that, but she has to make her services available to all those people on equal terms. Her speech is only incidentally being restricted, and that's okay. And there's a whole set of cases that Colorado relies on in the 1960s and 70s when we started to ban discrimination in public accommodations. We had a lot of business owners saying, it violates my free speech rights. I want to say white people are superior. I want to say no Black people allowed. I want to speak those messages. And these laws are violating my free speech rights. And the court said, no, that doesn't count as a free speech violation. You may still speak those messages, but you have to take down the sign saying white customers only, or lots of signs, right? No dogs, no Jews allowed. You have to take down all of those signs, and that's not a free speech violation. We're just regulating your conduct. You have to sell to everybody. You can keep your views intact, however. The court today, the Supreme Court, rejected those claims in this case. And it didn't locate this case in that line of cases. It located this case in another line of cases, which had to do with parades and private membership organizations. The Catholic Church wants to put on a parade, or and exclude gay people. The Boy Scouts want to exclude gay people because the Boy Scout says one of our messages is that homosexuality is wrong. And the court had said that those organizations could exclude gay people. And the court also put this case in a set of analogies where it said, filmmakers, speech writers, artists can't be compelled to speak messages they don't want. And they held that Laurie Smith, the website designer, is like that. She's like a filmmaker. She's like a speechwriter. They said her products are customized and tailored to individual couples. She's telling a story and expressing a message through original art. People will know that the websites are her original artwork when they look at them. And then the court says all manner of speech, movies, paintings, drawings, engravings, oral utterance, and printed words, so like novels, those all qualify for First Amendment protections. And that's no less true if for somebody who's conveying their art and their message over the internet. And they said, if we didn't find for this woman, the state could make a Muslim film director make a film with a Zionist message, and it would be government totalitarianism. So a blow for free speech. She doesn't have to. She can open up, make wedding websites, but she can exclude same-sex couples. So the question is, how expansive is this decision? Is this a big decision? Did this change a lot or not so much? We don't actually know the answer. I'll say a couple of things, though, that are responsive to that question. All right. Perhaps it will be very expansive. So perhaps we'll now have a category of public accommodations, which we didn't have before, right? These are public accommodations. These are businesses opening their doors to all comers that we now consider so expressive and so much like an artist or a filmmaker that they are going to get an exception on speech grounds to anti-discrimination laws. We're going to have to litigate a lot more cases. What about a baker who makes a custom cake and says it's expressing his message? He maybe even writes some text on the cake. What about someone who arranges some flowers and puts messages in the flowers and says that's their artwork? We're going to have all of those cases. And this may actually be quite a broad exception to anti-discrimination law for people who don't want to serve, people in the wedding industry, especially who don't want to serve gay people. The other way in which it could be expansive, it might not be limited to gay people. So in fact, there's nothing in this case that is limited to gay people. This is an exception from anti-discrimination law. So if you are a wedding website designer and you don't want to serve interracial couples, you are now allowed to, I think is the logic of this opinion. If you don't want to serve people, Justice Sotomayor asked a lot at oral argument, if you don't want to serve people with disabilities who are getting married because you're a eugenicist and you believe they shouldn't reproduce, you may not have to serve them because you shouldn't be compelled to speak a message that you think their marriage is okay. And there are all sorts of hypotheticals that this brings up. What if a school portrait photographer doesn't want to photograph an interracial child because she thinks that will express a message that interracial marriage is okay and it's against her viewpoints? What about someone who does corporate headshots and say, I believe women's places in the home, I don't want to create these images that speak a message I don't believe? The court says, yeah, there are going to be hard cases. There will be difficult line drawing problems. But I have to say, I do think we're going to see a reduction in protection. I do think that on the logic of this opinion, some of this discrimination will now be allowed. And the final thing I'll just say is threaded throughout the majority opinion, there was a description of anti-discrimination law as annihilating, wiping out, and excluding alternative viewpoints and being quite problematic on that ground. That is not generally how we've understood anti-discrimination law in this country. We've understood anti-discrimination law to coexist with free speech. You can't discriminate, but you can still speak your messages of discrimination. If we start to accept a view of anti-discrimination law as a suppression of messages that is problematic under the First Amendment, we could see a much more far-reaching attack on anti-discrimination law. 2 more points. I don't think the decision will necessarily be as broad as all of that. So if the court is inclined to limit it, I would say it does. There are some seeds in the opinion that would enable it to do that. All right. It focused on the fact that she was a true artist. Her creations were customized. They were tailored. She expressed her story through her websites. She promoted a message. People looking at the art would know that it was her message and her story that she was telling. It was not general. It was not specific. And her work was likened to paintings and films. So I think that somebody who rents chairs or wedding halls is going to have a hard time under this opinion, arguing that they can discriminate against Black people or gay people. It may even be that caterers are going to have a hard time convincing someone that their food art does this kind of thing. I think, as I said, we're going to have some edge cases, but maybe the bakers don't even win. The photographers probably have a better chance. What about the florists? What about the hairstylists? Lots of open questions, but I think there's enough argument there that maybe this could be a very limited decision to this person who the court is likening to a filmmaker or a novelist. The final thing I just want to say is reporters ask me a lot these days, oh, we had the Dobbs decision last year and everybody thought that that might strike at LGBT rights, but we still have same-sex marriage, so it seems like that's not going to happen. And I want to say that this is that happening. So regardless of how this shakes out in terms of the First Amendment, whether it's a big expansion of First Amendment doctrine, whether it doesn't actually have a lot of legs in other cases, I do think it's important to say that this case is part of a much broader context. It's part of a culture war. It's part of an attempt to erode the equal status that the same-sex marriage decision in Obergefell and the law decriminalizing the case decriminalizing homosexuality, Lawrence, these are both 21st century cases that really put gay people on equal footing with straight people. And this is what the campaign to erode and attack those decisions looks like. Here is an important foray into eroding rights, to saying that LGBT people have second-class rights. The Alliance Defending Freedom, which is the organization that brought this case, they are not simply a free speech, libertarian, First Amendment kind of organization. They are a Christian organization that wants to instantiate Christian values in the law. They promote don't say gay laws. They promote book bans. They promote internationally the criminalization of homosexuality, fines for promoting homosexuality. They authored the abortion ban in Mississippi that the court upheld in the Dobbs case. They supported SB 8, which is the law in Texas that says you can't aid or abet an abortion, including maybe even by talking about where someone might get an abortion. And this is their case. And it was designed to strike back at Obergefell and what the previous court did in terms of LGBT rights. I think viewed through that lens, one would have to say that this is a fairly substantial victory for anti-LGBT forces. We'll have to see how far it goes, but I think it has a lot of cultural and symbolic value, even apart from the specific First Amendment doctrine.
Great. Thank you, Cary, for that, for the analysis and kind of, just bringing to reality what actually is occurring with this case and with this litigation strategy. A reminder for those of you who have joined us more recently, if you have a question, you can ask it in the Q&A function that is there where it says Q&A at the bottom of your Zoom screens. We're now going to turn to our final 2 speakers before we take questions. Our next speaker, also just dealing with opinion, who came out a few hours ago, is Professor of Law at the Law School at UCLA, Joseph Fishkin. Thank you.
Thanks. In Biden v. Nebraska, which came down a couple hours ago, the court strikes down the Biden administration's student loan forgiveness plan, which is the plan that would have forgiven $10,000 for most borrowers, $20,000 for borrowers who received Pell Grants, which means you grew up low income. The Biden administration justified this as a response to the economic upheaval of the COVID pandemic. It was actually pretty well targeted in terms of getting relief to the group who are struggling the most with student loans, both before the pandemic and especially in and after the pandemic. There's an income limit. High income borrowers don't get anything. But for the very large number of Americans who started but didn't complete college, which is the group that has the hardest time paying its loans, even though they owe the smallest dollar amount, this often meant complete relief. And that group is disproportionately people of color, which is also true of the group who got Pell Grants, which led a lot of people to point out that this loan relief program would have had a significant racial equity effect. LGBT people are also more likely than others to have student loans. So in this lawsuit, a group of basically red states challenged the loan forgiveness plan because they disagree with it. One of the big disputes in the case was whether they had standing to sue, which I will spare you the details. I'll just say the court somewhat reached out to hear this one. This case probably should have been dismissed for lack of standing. And the court strikes down the loan forgiveness policy and says it exceeds the Secretary of Education's statutory authority. So on its face, this case is about the relationship between a statute authorizing emergency relief, the COVID pandemic, and this plan that the Biden administration came up with. But really, just to step back before we dive in, this case is really about the constitutional and legal vision of the current supermajority of the justices, which has as one of its really central pillars the idea that it's important to build new legal doctrine to rein in the administrative state, to rein in government, perhaps especially when it comes to government programs that seem to involve some form of redistribution. So from that perspective, this case actually fits in with last year's West Virginia v. EPA case, which struck down the Obama administration's 2015 Clean Power Plan. That case was another one where the court kind of reached out to hear it in the first place. And like in that case, today the court says the administration has taken a big, major, sweeping action, and we don't think it can do that under the broad general authorization Congress has given. This is called the Major Questions Doctrine. As a doctrine, it's pretty new. The dissent in this case by Justice Kagan calls it a made-up doctrine. Basically, what it says is when a question is really big, really major, we think Congress needs to have more specifically authorized what the administration does. So in that way, Chief Justice Roberts, in his majority opinion, frames what he's doing as protecting congressional authority against an executive branch that's kind of run wild. But really what the court is doing is disabling Congress. It's disabling Congress from granting the discretion to an agency that Congress is trying to grant. So this time it's the Department of Education, which Congress tried to give the power to grant student loan relief in times of national emergency. The statute here, it's called the HEROES Act. The acronym actually doesn't quite work, which is weird, but it's the Higher Education Relief Opportunities for Students Act. The whole point of this act was give the Secretary of Education the power to, quote, waive or modify any statutory or regulatory provision, unquote, about student loans whenever there's a national emergency or a war, so that the affected individuals won't be left in a worse position as a result of the emergency. So this is a very broad grant of discretion. It follows sort of narrower ones that had been keyed to the September 11th attacks, and Congress wanted to sort of more generally establish for the future that when there's a national emergency or a war, the Secretary of Education will have broad authority to make sure that people aren't left in a worse position in their student loans as a result. And the text of the statute says the Secretary can waive or modify any provision, including provisions related to forgiving the principal of student loans. Now, it's true, I think the majority is right that 20 years ago, nobody had this in mind. The COVID pandemic was not on anyone's radar. Most disasters affect a smaller number of people, not the whole country. But here we are. The whole country was affected by a massive disaster. And the response was both Betsy DeVos in the Trump administration and then Miguel Cardona, the Secretary of Education in the Biden administration. They used their authority under this act to pause student loan payments, which is why nobody's been paying student loans in the last couple of years during COVID. Now, the Supreme Court today does not actually say that was okay under the statute, but Chief Justice Roberts certainly implies that this pause was okay, but loan forgiveness is not. Now, an economist would point out perhaps here that the value of the pause for many borrowers was actually more than the value of the loan forgiveness. And if you extended this pause another couple of years, it would exceed the total cost of the loan forgiveness. But there's something about forgiving the principal of the loans that really strikes these justices as deeply different for reasons that are, I think, related to the anti-redistributive view at the heart of their constitutional vision. The majority is also bothered, I think, by the fact that this loan forgiveness plan comes close to the end of the official pandemic emergency. Of course, it's not the end of the economic impact of that emergency. Borrowers took a major hit as a result of this pandemic, and the impact of that hit will last years and for some decades. And the point of this loan forgiveness is to cushion that blow, which is what the statute had in mind. But the majority says this loan forgiveness just stretches the text too far. Yes, it says modify. That means a small modification, not a really big one. Yes, it says waive, but that means waive small bits of regulation, not major swaths of the rules. Yes, it says you can replace the waived language with other language, but that doesn't mean you can totally rewrite the statute. Basically, the majority, Chief Justice Roberts' view is the Biden administration is trying to completely rewrite the statute. And because it's so large a dollar amount, because we're talking about potentially $400 billion of lost revenue, that's just bigger than what Congress had in mind. At oral argument, Justice Thomas floated a suggestion that maybe forgiving this much in student loans was actually an appropriation, which is not technically true. But so I was kind of watching for that in the opinion. Chief Justice Roberts doesn't endorse that view, but he winks at it a couple times. When Justice Kagan in dissent says that student loan forgiveness is right in the Secretary of Education's wheelhouse, Chief Justice Roberts responds, in light of the sweeping and unprecedented impact of the Secretary's loan forgiveness program, it would seem more accurate to describe the program as being in the wheelhouse of the House and Senate committees on appropriations. As in, this just feels like we're spending a lot of money, and that should be up to Congress. Chief Justice Roberts quotes an article pointing out that student loan forgiveness raises questions that are personal and emotionally charged, precipitating a profound debate across the country, which is true. But the dissent says you still have to follow the text of the statute. The dissent argues that the major questions doctrine is, quote, a rule specifically crafted to kill significant regulatory action. And that just seems true. I mean, that's what this new doctrine does. It highlights things that are major. Often they're major because they're controversial, and often because of their broad economic impact. And so I guess in conclusion, this is an important case in terms of administrative law, but it also gives us a window into the vision of political economy that the current supermajority on the court holds, which is not just a statutory interpretation vision, but a constitutional one. It's linked with constitutional doctrines like the non-delegation doctrine, which also try to block Congress from doing major things in the economy. In the meantime, the concrete impact of this case is this is going to be a kind of short and medium-term disaster for a generation of student borrowers. I mean, this isn't necessarily the end of the line for loan forgiveness, but it's the end of the line for now. Now student loan relief will become a major issue in the 2024 congressional and presidential elections. And interest starts accruing in September and payments are supposed to be due in October. So it's a long way from here to 2025.
Great. Thank you so much. We're going to turn to our final speaker, and then we'll have a few minutes left after that for some of your questions. I'm really happy to introduce a colleague and good friend, Brenda Suttonwillis, who's Assistant Dean for Diversity, Equity, and Inclusion here at UCLA School of Law.
Thank you, Brad, for the introduction. I think the first point in answering the question of how these decisions affect the UCLA Law community is to reiterate UCLA Law's commitment to diversity and inclusion that Russell sent out earlier. As a law school, we'll continue to value diversity and insist on inclusion, not only because it's the right thing to do, but also because it's essential for training effective lawyers who will represent and advocate for people from all parts of our nation and our world. Notwithstanding the scholarly input of my colleagues and the institutional readiness of UCLA Law, diversity isn't a restorative social justice program. There's a lot that we're doing as a law school under the inclusive teaching leadership of Cheryl Harris. We're working toward an inclusive teaching environment. Jerry Kang, Anna Spain Bradley, Devin Carbato are some of my colleagues at the law school who are scholars and thought leaders in DEI. And we have programs and centers, including CRS and the Williams Institute and our Rand Schrader program and PILP and our legal clinics that all equip us to embrace diversity and support inclusion and service to those who are underrepresented. I think we need to understand, even with the institutional support, diversity is the natural float point. Preparing our future successful attorneys and getting toward effective representation for all communities means supporting the natural float point of diversity and working against the factors that undermine diversity. Nothing in the court's decision absolves the community of good faith from its responsibilities to act against those biases, both implicit and explicit, that undermine the natural float point of diversity. Diversity is organic. If you look at a cross-section of the brightest preschoolers in Los Angeles, that's going to be a diverse group. Some kids will have the advantage of a birthing parent who will have received excellent prenatal care. Some will not. Some will be unhoused. Some will not. Some students will have the advantage of generational know-how and scaffolding to systematically and strategically pay for advantage and exclusion. Some of those students will practically be delivered to the doorsteps of academic institutions. Some will not. Some students will receive mentoring and high quality supplemental tutoring. Some will not. Some will receive excellent housing, healthcare, mental wellness resources, and very limited or no engagement with law enforcement and the school disciplinary system. And some will not. The Williams Institute, CRS, the Promise Institute, to name a few UCLA law institutions, have statistics measuring the erosion of equity and the conjoined erosion of diversity that occurs in our society. And, just to paraphrase Justice Ketanji Brown Jackson, turning a blind eye toward bias and racism doesn't make it disappear. So when we as a community of individuals come forward, we need to personally commit to understanding the biases that undermine the natural buoyancy and float point of diversity. There are many actions that a person can take to restore diversity's natural buoyancy and to work toward inclusion, retention, and equitable participation in legal careers for our students and alumni within their first 5 years of practice, and equitable representation for underserved communities. What we can do is take this time as a Bruin law community at large to embrace our pre-law students, our law students, and our new alumni through purposeful DEI initiatives and DEI-informed strategic mentoring. We'll pull you into our efforts. We're in the process of offering training and building strategic mentoring opportunities to create a sustained dialogue and support a system for law students and new attorneys through a diversity consortium anchored by our very strong alumni association base, including our alumni association board members. Bias continues to work against the natural float point of diversity, and that bias produces outcomes that do undermine the effective legal representation for entire communities, leaving them exposed and underrepresented. And restoring that natural float point of diversity is the true calling of DEI training and authentic DEI engagement in the legal profession. As Russell stated, UCLA Law's UCLA Law's commitment to diversity, and of course, with the support of our incoming dean, Michael Waterstone, we're going to continue to act to support our commitment to diversity, equity, inclusion. Brad, I'll close here saying I look forward to continuing the conversation.
Great. Thank you, Brenda, and thanks to all the panelists. We do have a few minutes left for questions. I appreciate all of the questions in the Q&A. We're not going to probably be able to get to all of them given the time. So I want to focus on pulling together a few that cut across some of the cases. So if all the panelists want to come back on screen. Jerry, I thought we'd start with you, and some of the questions go to whether this court does not have as much respect for precedent as it should, either kind of in general or when it comes to social justice issues like the issues of race, sexual orientation, and reproductive rights last year in Dobbs.
Yeah. Hey, great question. I'm sure Cary has a lot to say about, again, what they did in Dobbs. Here's what I found really interesting. In the SFFA versus Harvard UNC case, they're not as explicit as they could be about we are overruling Bakke, we are overruling Grutter, Fisher, all those cases. They kind of dance around it, although everyone realizes, including concurrences and dissents, that they are effectively overruling this really important precedent. Why are they dancing around it? And also, why does Kavanaugh have a whole concurring opinion saying, hey, remember when Justice O'Connor back in 2003 and Grutter gave us a 25-year shot clock? We knew it was going to go in 25 years, and it's not quite 25 years, but it's close to 25 years, so no reliance interests. I think it was in response a little bit to the pushback that they experienced post the Dobbs decision. So I think 5 beats 4. Now 6 definitely beats 3, and I think they're very muscular in pursuing the goals that they need to achieve, but stylistically they're performing a little bit less in-your-faceness in the Harvard SFFA case in light of maybe some of the heat and loss of institutional legitimacy they saw from the Dobbs decision. But I'd love to hear how Cary thinks about it.
Yeah, well, I'm not sure I have anything profound to say. On the precedent question, I'll just say, yeah, this court is slashing and burning through precedent at an unprecedented rate, at a very quick rate. I think that many of these justices were put on the court to do that the president announced that he was putting them on the court to do that. They are doing what they were put there to do. They believe the Constitution has been interpreted wrongly in various ways. I think Justice Thomas said, we can't do it quickly enough. We need to bring the Constitution back to the correct interpretation. They're very unapologetic about it. I think from a democratic legitimacy standpoint, there are some real problems with the way the court is going about this. This is not judicial minimalism. This is not an attempt to negotiate between competing ideologies and views and communities in this country. It is the enforcement of a particular view of the Constitution. And, I think a lot of people's sense of that will depend on whether they share the vision of the Constitution that this court has or not. And there also is the independent question of whether you believe a court should behave like this, or whether a court should take a more incremental approach in order to be more open and democratic and accountable.
Great. I think this is going to come back probably mainly to you, Cary, and to Jerry. But I think, Jerry, you mentioned that the affirmative action cases were kind of an AstroTurf case, wasn't like a real grassroots organization. Cary, I think, this is a web designer who I believe has never done a wedding webpage before this case. Is something different going on here in the way these cases are being designed, and are the tactics something the court should be paying to, and or different than what the more progressive groups are doing?
Jerry, you start and I'll follow up.
Look, I think we should not be shocked that, again, cause litigation, regardless of one's cause, actually does what it takes to find, again, procedural avenues, which includes finding plaintiffs. And again, to be open, to be broad-minded about it. We have a long legacy of, even in the civil rights context, of, again, curating plaintiffs, the anxieties of serving multiple masters, focusing on the plaintiff's interest versus the larger cause litigation, and we should be sophisticated about that. It's just that I don't think we should be, again, naive in seeing this process, and how, given the fact that there's been so much success recently, that it will largely continue. So to the extent that we have anxieties about how Title VI will be leveraged, how Title VII will be leveraged, there will be, in some ways, manufactured plaintiffs that will use rinse and repeat practices to go after a lot of the things that we care about as being fundamentally fair. We just shouldn't be shocked about it.
And I just wanted to add about the 303, because there's been a lot of reporting in the last 24 hours. I think a reporter for the New Republic found a request that this wedding website, or this aspirational wedding website designer said she received from a same-sex couple, called up the person. And I believe he's married to a woman and has children, and said, I had nothing to do with this. This is completely a fake. This is a fake request. I never made it. And it also looked like he was asking for invitations, and maybe they were thinking about maybe bringing this case as a case about a wedding invitation design, and then they decided to do a website. So this case, clearly, they were looking for a narrative, they were looking for a plaintiff, they worked in constructing it. Again, not a shocking thing. A lot of impact litigation does begin looking for an attractive plaintiff. I would say any good lawyer wants to look for an attractive plaintiff. It's true that this case really was manufactured by this group. I do want to say, though, that fake gay couple never factored into the case that reached the Supreme Court. It got to the court as a pre-enforcement challenge. She was saying, I haven't entered into the business yet, but I can't, because if I do, I will be brought up on charges before the Civil Rights Commission. And everybody kind of agreed with that. So it didn't become part of the case. Everyone agreed it was a pre-enforcement challenge. The thing I just want to say, and the thing I think is important, is there was a predecessor case to this that involved a baker also in Colorado. A same-sex couple came with their mom to his bakery. They wanted to try red velvet or lemon chiffon. What were they going to do? And the baker said, I'm not baking for you. And that was somewhat sympathetic to people in America, saw these cute people. They just wanted some cake. And Americans didn't like the idea that their day was spoiled, and that they could understand the discrimination and the upset that those people feel. So the Alliance Defending Freedom are smart. They said, let's design a pre-enforcement challenge so there is no gay couple. There is no cute love story. There is no mom who's thrown out into the street without cake or a website. It was a strategic decision not to have any gay couple that got discriminated against, because they knew that that would be bad for them, because people don't like that kind of treatment. And so they designed a case to cover that over, so that the only person, the last thing I'll just say, the only person in the media was this website designer crying and being photographed behind like live, laugh, love signs in soft light saying, I can't do my business because the government's discriminating against me. And there was no one on the other side showing what the ramifications of her claim were. That was a tactic. I think it was a smart tactic to cut out gay people. Not nice, but on the last thing I will say is there's something positive to me as an advocate of gay rights, the glass half full. They didn't want the gay people there because they thought Americans might like these gay people. That's a good thing.
Just to add one point connecting these first two questions, you know, the manufactured plaintiff situation is sort of symptomatic of a court that is reaching out to do a broad, you could say, constitutional vision, ideological project, whatever, that's connected to the values of a political party that appointed the justices to the court. Now, obviously, we're in a funny situation because justices don't like to say that we're engaged in some form of politics, even if it's a high rarefied form of politics. And that's why there's so much anxiety on this court around the question of whether they can justify what they're really doing in either originalist or textualist or some set of terms like that. In the student loan case, there's a lengthy kind of elaborate concurrence trying to reconcile the major questions doctrine with textualism, which is very hard to do. And in the affirmative action cases, you know, Justice Thomas tries it, but the main opinion by Chief Justice Roberts completely eschews any discussion of the original intent of the 14th Amendment, because originalism is not on their side in that case. And so there's a kind of problem here for the majority, the supermajority on the court, that it's engaged in a project to transform the law, and it needs to justify that in some terms other than that it's a sort of political project.
Well, thank you so much for that. Really compelling points from each of you. I think given the questions, and they're now coming in kind of faster, we're just going to have one left, but it's going to pull together at least the pulse of a number of questions. I think we could all use a little cake today, but I hope you find that in your life. But people are looking for, how do we move forward? I'm going to do something awful and ask you to each just try to say kind of one or two things in about 30 seconds of how do we move forward. And here it can be in terms of access to higher education, new legal arguments, switching forms, like what do we do next? Joey, why don't we start with you, and we'll just go around the four of you. Thank you.
Sure. Well, all of the above, but I do think it's important to begin with a recognition that politics and what happens in court are not two separate things. They're linked. The reason we have this supermajority today is because of decades of conservative backlash against the Warren Court, against LGBT rights, against abortion rights, against the growth of the administrative state and many other things. And so today, I think we're in this pivot time where we're beginning to see the mirror image of progressives beginning to argue in politics against the court. And so I guess my short answer is it's important to have that process happen, because this is part of how the court over time, over American history, is kept in line. And is kept close to what Americans actually believe is by political activism against the court, eventually having an effect.
Okay, Brenda?
Thanks, Brad. I think that many of our students and many pre-law students will see these decisions as kind of a punch to the gut. that they don't belong, whether they're from the LGBTQ community or any other underrepresented community. And I would just say to the predominant group of alumni out there that the Supreme Court is not meeting with you over coffee with pre-law students and law students and supporting diversity and in your individual actions and the actions you take to support diversity and bring diversity back to its organic point. So you do still have the power to support diversity, and the California state school system has already been under Prop 209. We do have the power to support diversity, and we've worked at it over the years to get there. So again, there's a visceral reaction to this line of cases, and we can go on about that, but we should not feel that we don't have power to act and support our communities. Thank you, Brenda.
Jerry.
So I co-sign everything Joey said about politics. I got to say that I still believe that sharp legal analysis is a form of academic politics. It's a form of straight out politics. It's a form about holding power accountable and speaking truth to it. It might be clueless. It might be overly optimistic. It is what I do. It's, I think, what we all do. And so actually using our minds to reveal the ways in which power is wielded in hypocritical ways, I think is a form of really important politics. And I will always continue doing that. And I encourage lawyers to develop those skills, and law students, obviously, to develop those skills to do that. That is hardly sufficient. I think it's actually absolutely necessary.
Cary.
Yeah, I'll say two things. One is, I think there's so much room for creative lawyering. And I think actually we have a very good model of it on the right. They lived through a long Warren Court era when it looked like the challenges were insurmountable. They were creative. They tried different arguments. That is now the lot that we have, and we can be just as creative. I think there's been a lot of expansion very recently of free speech and free exercise and First Amendment protections. How about you flip those around for people who feel like their speech and exercise is being suppressed? There are different ways to frame constitutional arguments, and I think there are just lots of creative on all sides. And I think that's a real part of a way to be involved if you're a lawyer. I would say for everybody, politics, politics, politics. If it wasn't clear to you before, the court is not the answer. It's not the end. It's not going to save you. It's not the only venue. It's very important to organize for what you believe in, to try to get laws passed, to ask questions of your politicians, to talk to your community members, to become involved with your school board, to get involved with the political area and get legislation that reflects your views. And the last thing I'll just say is, I don't think this is a time at all for complacency in the LGBT rights space. If anyone felt that over Obergefell, they shouldn't feel that anymore. There is a massive onslaught going, but it's not a time for despondency either. There's a lot of victories. The cases are going both ways. It is a time for major engagement by everybody who cares about these issues.
Thank you. And I want to thank all of our panelists for their incredible and very quick work today. And just say one final thing, really directed to the UCLA Law community and particularly students. You belong here. You got in through the front door. You got in through a very competitive and rigorous process where our admissions team knew who you were as well as you can from the application that's submitted. So claim your seat. You have a right to it just as much as anyone else. And if you're thinking about applying to the law school or UCLA, we not only want you, we need you. Our future and our success is really dependent on you. And whether you're applying next year or you're in 6th grade thinking about being a lawyer, myself or anyone on this panel would be happy to talk to you about the different pathways and encouragements that Brenda mentioned so you can join our community. So thanks to all of you for being with us today. We really appreciate your time. Thank you.